Welcome to In Your Defense, Galveston and Beyond.
Welcome to In Your Defense, Galveston and Beyond with Mark Diaz and John Clements. Mark is a passionate criminal defense attorney with over 25 years of experience defending the rights of Texans. And together we're excited to discuss all things criminal defense law. So Mark, welcome to the podcast.
Thanks for having me back.
You bet. It's always such a fun conversation with you. I'm looking forward to it. So today's episode, we're talking about caught with a gun during another crime, what it means for your case. So Mark, let's just dive into it. You're in Texas. So tell me, in Texas, what happens if someone is caught with a gun or a firearm while they commit another crime, say a DWI or drug possession?
So you'll end up with another charge for unlawfully carrying a weapon. And this happens a lot, especially with DWI, because a lot of Texans have guns in their car. And so then they get charged with DWI during the inventory search of the vehicle. An inventory search before a vehicle can be towed, it has to be searched and document everything in the vehicle so you can't later say something was stolen or whatever by the record driver or police or whomever. And so during the inventory search, they find your gun and then you pick up a second charge of unlawful carrying a weapon. They do the same thing with like marijuana cases, basically anything. In most situations in Texas, it's lawful to have a gun unless you're committing a crime.
I see. Yeah, that was my next question is, let's say I've got all the proper certifications and maybe I have my, concealed carry license. And so I'm doing everything by the book. But if I'm also driving while intoxicated or have an illegal narcotic, that pretty much makes what I'm doing doubly illegal. That's what I'm hearing.
Yes, that's correct. And even if you have a license to carry, it's the same rules, because as a license holder, you're supposed to know that you're not supposed to be carrying a gun while committing a crime. And so it even happens to license holders. And, they are more concerned about losing their license many times than whatever conviction would come.
Yeah, I can imagine. And I want to talk a little bit about that conviction element. So you've mentioned that if you were caught with the firearm while committing a separate crime, basically you're looking at two charges now. So does that increase the potential penalties or fines or God forbid, jail time a person might face?
Theoretically, on paper, it would. In reality, what happens most of the time is if you work out the primary case, they'll dismiss the weapon case. So if you end up taking a plea on the DWI, they would dismiss the gun case along with the plea to the DWI. Does that make sense? And so, But yes, it would be another misdemeanor charge. It would carry a separate punishment, but at least in my practice, it doesn't happen. I recently had a client who was arrested for, they said racing, and he had a weapon in his car, so they charged him with unlawfully carrying a weapon. And I was able to show that he indeed was not racing, but he did peel out a little bit when he left a stoplight. Anyway, I was able to get the primary case dismissed, which then that means they couldn't get the unlawful carrying of a weapon, so we got both dismissed. But the gun cases usually go away with the primary case. There would be exceptions with felonies. If we're in a felony situation, but then they offer to plead to a misdemeanor gun case, then maybe my client would take it. It's going to depend on the circumstances.
Yeah. And I do have a question about that circumstance because let's say you've got two identical cases, let's say two DWIs, both unlawfully carrying a weapon. One person has maybe a concealed carry license, has gone through all the training, should know all the rules, and maybe another person is already a convicted felon and shouldn't have a firearm to begin with. Like, is there any difference materially in those two kinds of unlawful carrying?
Yeah, huge difference, because the felon in possession of a weapon has now committed a felony by carrying a weapon while he's prohibited from doing so. So that's going to completely change everything if it's a felon, because that's a separate. So if it's a DWI, but the guy happens to be a felon and has a gun in the car, he's going to get the misdemeanor DWI, and now he's going to get a felon in possession of a weapon, which is obviously much more serious than a misdemeanor.
I see. So I think your advice from a previous show still applies. If you know something is illegal, don't do it.
Yeah.
And if you have a license, you should know better anyway. So you mentioned that that it's often possible to, if there's, a gun charge and another charge, if you can get the other charge, removed, taken away, then the gun charge can often be removed as well. But in the event where that's not possible, then do those two charges stack to, in effect, make things worse?
So legally speaking, that could happen. It's never happened to me. But yes, on paper, you could be in a situation where you had both of those misdemeanor cases and the state moved to stack those sentences and the court granted that motion to stack, then yes, you could get more punishment.
I see.
But
But I mean,
the,
yeah, yeah.
the thing about unlawful carrying of a weapon is it's usually attached to a misdemeanor. And so we're not usually talking about stacking sentences and whatnot happens on serious felonies. It doesn't happen in misdemeanors.
Got it. Oh, that's a good distinction to make. Yeah, that makes sense. I wanted to talk too a little bit about, so you're a defense lawyer. You're looking at it from that point of view. And I want to talk about prosecutors, because how do they look at these gun possession charges, and especially say during like a plea negotiation? How does that affect any kind of plea deals you might be able to make?
So one thing they like to do on gun cases is offer a dismissal if my client will agree to the destruction of the weapon. So depending upon your situation, for a lot of people, it's a no-brainer. Like, yeah, I'll sign a destruction order if it means I get a dismissal. Because we obviously have rare occasions where a person is charged only with unlawfully carrying a weapon. And then if they offer, hey, I'll dismiss it if your guy will sign a destruction order, a lot of people say yes. I have had the occasional case where my client was like, no way. My grandfather gave me that gun, some sentimental value. But a lot of times people just say, yeah, I'll go get a new gun.
Yeah, the price of a new gun is, I'm sure, I'd be willing to pay that if the alternative was, much worse, I'm sure.
Right.
Yeah. So we talked a little bit about how, like you and what you do are often successfully able to, get things thrown out or taken care of or dismissed or whatever, or what have you. But I am curious to know, are there any situations where if you are carrying a gun during a minor offense, whether it's maybe like a traffic stop or a low-level drug charge, can that turn it into something more serious?
So a traffic stop, not really. I mean, I'm trying to think of a situation where I could make it. A traffic stop, generally no. A drug offense, yes, because it could add the unlawful carrying of a weapon. When we say that you can be charged with unlawfully carrying a weapon, we're not talking about, I mean, when we talk about the charge, meaning you can't have a weapon while committing a crime, that doesn't include traffic, right? So speeding isn't a crime that would warrant you getting a charge of unlawful carrying of a weapon. But possession of drug, yes, because that's an arrestable offense. So even if it's a misdemeanor amount of whatever drug, it's going to lead to the extra charge of unlawful carrying of a weapon. Now, what you may be looking at is a situation where, like, a pill is found in your car and, the officer's probably going to let you go, but then he finds this weapon. I don't, generally speaking, on very minor stuff, no, it's not going to lead to any future problems. But again, it could if your attitude is wrong or something. But generally speaking, it's only going to enhance arrestable offenses.
I see. Yeah, I appreciate you making that distinction as well. The traffic, if you're speeding, you're typically not going to be arrested for that unless you're really speeding. So it's good to think about those distinctions. So let's talk about if there's a person who's facing both, some other charge and a gun enhancement charge, like what defenses are available to that person in the courtroom?
So usually, right, unless it's like an aggravated robbery where a gun is used, right? Usually the gun is found as a result of the primary offense. So if I can find a way to defeat the primary offense, then the gun goes away anyway, right? But if the gun was used in the commission of the offense, then it obviously makes it a much more serious situation. So if you look at aggravated assault with a deadly weapon, in Texas, almost anything can be a deadly weapon, right? I could threaten you with a fork, and that could be considered a deadly weapon, right? Because I could stab you in the neck and blah, blah, blah. But it's certainly mitigating if my deadly weapon is something ridiculous, right? But it changes the game if I stick a gun in your face, because that's real, right? Most of us have never had that happen to us. So yes, it can affect the seriousness of the charge and the seriousness of any consequence. But again, it's more common that the gun is found after the commission of another offense. So it's just going to depend on the situation.
I see. Yeah. And as we started with the conversation, it's having the gun while you're committing another crime.
Right.
That's the piece of the puzzle. Yeah. So it makes sense that if you're able to get the primary crime dismissed, then the gun charge would most likely go away.
Right.
And then I also wanted to know, let's say that let's say that I'm arrested and gun possession is a part of the case. Like, what's the most important thing that I need to tell you as my defense attorney?
Everything. So details matter, right? Like we've spoken before about intent and knowledge of an offense. So we have had situations where you borrowed someone's car, and then a gun is found in the car, but the gun is like under the rear passenger seat. There's a pretty good defense that I didn't know that gun was there, right? It changes, of course, if it's right here between the seat and the center console and I can see the butt, right? That changes the situation. So what I need to know is all these details. The other thing is, in Texas, we don't really have gun registry, right? Now, if you buy a weapon from a dealer, then your name goes along with that gun, right? But if 5 years later you sell it to your neighbor Pete, there's no record of that transaction, right? And so I might want to know the registration of the gun. In other words, is it registered to you? Did you buy it at Academy? If they run the gun, is it coming back to you? Another reason it's important is because while we don't really have gun registry after the initial purchase, we do have, the state does keep records of stolen weapons, obviously, and where they were stolen and when they were stolen. And so if you're in possession of a gun that comes back as stolen, well, now I got bigger problems because you might be a suspect in something else. So it just kind of goes back to what I need from you is true information, so that when I walk, if you tell me the gun is registered to you or registered to your neighbor, and I walk into court and I say the gun's not even registered to him, it's registered to his neighbor, and they say, no, it's not. Your guy bought it at Academy last week. Here's the, you know what I mean? It puts me in a bad situation. So it's just like everything else. I need you to be honest with me if I'm going to do the best job for you.
Yeah, absolutely. Yeah. Don't lie to your lawyer. That's a bad move.
Yeah.
Yeah. So Mark, it's again, as always, it's been super interesting to pick your brain about these subjects that are important subjects, I think, and that we don't talk about enough. So thank you so much for being on the show today.
For having me. I enjoy it.
Absolutely. And to our guest, I want to thank you for hanging out with us today with Texas criminal defense attorney Mark Diaz. To connect with Mark, you can visit texascriminaljustice.com. And as always, please like, subscribe, and leave a review. And with that, I hope you have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.